and we will produce it as soon as possible, and certainly in time for your next review session. That being said, our presentation today does not by any means exhaustively reflect the comments from the bar, but we will be presenting on a few main areas. Our core view is that given that this bill is intended as a specific carve-out from an area that is currently criminalized, it is in the public interest that this bill gives clearly defined parameters for conduct. The areas that we will be addressing are, first of all, who qualifies as a patient for use under the legislation. Secondly, issues related to access to medicinal cannabis by young persons as defined in the Act. Eligibility to apply for a license under the Act and certain exceptions thereto, as well as general comments. I will address you on the first two issues and the final one, and my colleague, Mr. Leslie Roberts, will address you on the issues related to the eligibility to apply for a license under the Act, and I will turn to him when the time comes for him to present. First, in identifying, it is important that this bill identifies who qualifies as a patient for use using medicinal cannabis. The bill specifies or contemplates use by patients who are either resident or non-resident in Barbados, specifies use by patients who are minors, those who are those who are under the age of 18 years, use by young persons in the 18 to 21 year age group, or adults, those over 21. However, careful drafting is required, as all other categories of patients are based on this core definition of what a patient, who a patient is. And in the bill, a patient is simply a person who suffers from a medical condition, which may be treated with medicinal cannabis, prescribed or recommended under the Act, pursuant to the Act. And as I said before, all categories of patient, minors, persons, and visitors, are based on that definition. The issue that we will raise today, given this definition, is the issues attributed to visitors under the Act. Patients, the definition of patient, in our view, is limited. The bill contemplates a separate regime for how non-residents, defined as visitors under the Act, will access medicinal cannabis in Barbados. However, that regime is not yet identified. Section 42 of the Act contemplates that this regime will be dealt with in subsequent regulations, but as currently defined, a visitor may not include a minor or young person that is not resident in Barbados because of this limited definition of the term patient. The bill, therefore, does not presently afford to non-resident minors and young persons the same access as it does to Barbadian minors and young persons. It's not clear to us whether this distinction is deliberate. If it is deliberate, then the possible rationale for this distinction is not clear. In our view, the current drafting may be retained once the definition of patient is expanded to include minors and young persons, and further comments on this will be contained in our report. Our second area of concern is the access given to young persons under the Act. Now, generally, patients may access medicinal cannabis via prescription from a medical practitioner, or a recommendation, or that the use of medicinal cannabis is required based on a recommendation made by a medical practitioner. So it's either prescription or recommendation. In the cases of young persons and minors, and as I mentioned before, minors are those under 18 and young persons are those in the 18 to 21 year age group. There's an additional layer of protection in the Act itself. It's an intended safeguard we've observed. In the case of these categories of patients, they may access medicinal cannabis only with the involvement of a parent or guardian. That parent or guardian must obtain an additional certificate from a medical practitioner stating that the use of medicinal cannabis is absolutely necessary. And that parent or guardian must also give written consent to the use of the medicinal cannabis by the minor or young person. The bar is compelled to highlight that a number of legal issues arise, specifically in the case of those persons in the 18 to 21 year age group. For example, the age of majority in Barbados is legislated as 18 years. At age 18, these young persons, as defined in the Act, in the bill, are adults. They're capable of independent decision-making. The additional layer contemplated in the bill for young persons, is inconsistent with this legislation. The bill does not provide an alternative mechanism for access by a young person if parental consent or involvement is not available or forthcoming. And there are very easy examples of this. A parent may be deceased, a parent may not be present, or simply not involved. In fact, parents may also just disagree on the method of health care to be provided to their child. And to be clear, the bar is not opposed to safeguards for this age group. Whether or not this requires involvement by a parent or guardian is less clear. We therefore suggest that the drafters give further consideration to alternatives to parental involvement. Examples of this would be additional medical certifications. Our view is we must remember the legal impact that this will have on patients as well as a social one. We now turn to our third issue, which is the eligibility to apply for a license, and I'll ask my colleague, Mr. Roberts, to address the panel.
Hello, good afternoon. Hi. Yes. Hello, good afternoon, and thanks for having us as representatives of the Law Reform Committee of the Bar. With respect to the eligibility to apply, I want to refer specifically to Section 32 of the bill, subsection 3. This is page 28 of the bill. And it speaks to the eligibility, or rather the lack of eligibility, of a person who has been convicted under previous drug enactments, or rather existing drug enactments, because they're not being repealed. This is the Drug Abuse Prevention and Control Act, CAP 131, and the Proceeds and Instrumentalities of Crimes Act 2019. There is a further provision at Section 28 which speaks to caregivers, and that also prohibits a person who has been convicted under the Drug Abuse Prevention and Control Act from being designated as a caregiver. But the most significant point that I want to raise here in brief is the fact that the Act seems to be creating a sort of double jeopardy or a secondary punishment for persons who would already have been convicted under existing drug enactments. And I think consideration should be given to a perhaps more nuanced approach where we take consideration of, for example, the length of time that a conviction may have been on someone's record, whether or not that conviction may have been obtained at a time during their youth, in circumstances where there may have been mitigating circumstances, particularly as there is evidence to show that in many cases, convictions may attach to persons who are in underprivileged circumstances and underserved communities. And we may, in effect, be excluding persons who have a lot to gain from the medicinal cannabis industry.
Counsel, do you not think there's a reason why we've included the word indictable in that particular clause?
Certainly, I took note of the word indictable, sir, Queen's Counsel, and to be fair, I felt like there was not enough clarity on whether or not it meant solely indictable or triable either way, which includes the possibility of summary conviction or indictable if referred to the High Court. So perhaps that can be clarified at a later date.
It says convicted of indictable offenses. So there's no issue of what it.
Oh, convicted on indictment.
Yes, it says
understood.
Convicted of. I mean, let us remember your opening statements. The team's opening statements recognize that this was a carve out from from a law which deals with criminal conduct. And it is because we don't want to stop an individual from providing care to one of his relatives or a friend or whatever it is in appropriate circumstances that we have tried to make sure that the system is itself protected by requiring that that person should only be convicted of a higher order of things. So somebody who has been charged with a joint will not be affected by this at all. On the other hand, a person who is charged and convicted with one of the more serious offenses, then we're leaving that person out of the mix. And this is not unique to Barbados. We in fact talked about it earlier today, and recognized that Jamaica has a similar arrangement in place for a prohibition of people who've been convicted of a more serious order of things. Anyway, I apologize for interrupting you.
No worries, sir. No, I understand the explanation. Just 1 second. Yeah. I'll allow my colleague, Ms. Pilgrim, to respond.
Yes, I think the discussion in committee centered on the further stigmatization or the prevention of not allowing that person to legitimize their conduct. Yes, we did recognize that we did actually recognize the more serious offenses were the ones being contemplated by the Act. However, the core issue, and it's not necessarily a legal issue, technically, is that this person who may have been penalized in the previous regime would now not have the opportunity to make this a legitimate business, which we thought was more of a social than legal issue, but we thought we would raise it for contemplation by the committee. Okay. Our final point for presentation today is just a couple of general comments. And these relate to the identification or registration of patients and caregivers under the bill, the basis for a doctor's recommendation under the bill, and finally, the regulations.
Please cite the clauses.
Yes, we'll do. Okay. Well, this is a general comment. This is a general comment, and actually will appear as a general comment. Now, the bill provides for. Identifies that certain persons may be caregivers of patients, and that these caregivers, it recognizes that patients themselves may not be able to attend a pharmacy, collect prescriptions, and so on. I think that's section, just 1 second. Yeah, going back to, thank you. Yes. However, the bill, in our view, does not stipulate a definitive process for either patients or caregivers to be readily identified as authorized users or couriers of medicinal cannabis. Aside from the broad criminal penalties already attaching to use and possession of cannabis, there are also other criminal penalties in the bill. The bill makes it an offense for a person, this is section 40, the bill makes it an offense for a person to possess medicinal cannabis if he or she is not a caregiver. And it's also an offense for a person to allow another person who is not authorized to use medicinal cannabis under the Act to use medicinal cannabis. And the penalty for this is, in section 41, a person guilty of either of these offenses is liable on conviction on indictment to a fine of 15 times the value of the medicinal cannabis, or to imprisonment for a term of 10 years, or to both. And the concern is, how are patients and caregivers to be identified? A lack of identification as a patient or caregiver may give rise to scenarios where these persons may be unnecessarily subjected to police stop, search, and/or arrest procedures. The bill or the regulations to the final act should clarify how caregivers and patients may be identified for the purpose of possession and transporting medicinal cannabis for the benefit of the patient. Our second point, sorry.
Don't go too fast. One of our concerns as and as Attorney General, my office would have been responsible for drafting the policy that was determined. What, as policymakers, we are not inclined to do is to require individuals who are using cannabis for medical purposes to have to walk around with a cannabis ID and say, well, I am using cannabis. Doctors will prescribe opioids, right, Dr. Brown? But I'm sure. But those patients don't walk around with any special ID card saying, well, I have a prescription for using something which is otherwise considered to be illegal. What we want more than anything else is to remember that in the medical sphere, we're really catering to people who are ill. And we want to treat them in the most respectful and humane way. And as policymakers, we were not comfortable with the notion that a person who was using cannabis for medicinal purposes should have to walk around with any special ID in case the police stop them. If the police stop them, there are ways and means of establishing that you are authorized to use cannabis. Now, I really don't think that a person who's, and I'm not a doctor, but if maybe one of the doctors here could tell me what kind of, they prescribe cocaine extract or something? Morphine, which would ordinarily be an illegal. Right. So a person who is in possession of morphine simply doesn't have that particular impediment, and therefore we didn't think that a patient who lawfully had medicinal cannabis should have to have any special ID, nor should a person who is a caregiver. We want to have a regime that is, well, there are restrictions to it. We want to have a regime that is workable for people and that doesn't put them through additional hoops. So that's the policy position that we were taking. As for identifying a caregiver, I think the first section says that a patient may designate. Okay? And once that person is designated, then it is not for a pharmacist or a doctor to go behind that. Okay? Our only caveat is that that person must not have been convicted of a criminal offense.
Well, the point is taken, Mr. Attorney General.
I'm not arguing, I'm just trying to.
No, I
to put
understand.
a-
I'm just
to explain
not
how we
sure
saw it.
that address, the policy position is noted. However, how the legislature intends to address, the method by which the legislature intends to address this issue, we consider it extremely important to highlight that it exists. We do understand that there are other methods, subsequent methods that might be employed, other ways that might be employed for the police to verify that this person is an authorized user. However, this is probably going to be after an emotional stop, an emotional search, and detention, possibly not just detention at the site, possibly at a police station for carrying. And these are things that we would wish to avoid. So whether because we do I understand your policy point about not having a card or identifying a person by a card. There may, however, we do think it merits further consideration of a means of identification. There are other, there are states, for example, in the United States that have an authorized persons regime. We will probably highlight this more fully in our report, given the interaction that we've just had. But we do think that it is important for these persons not to have to endure, based on the broad criminality still attaching to this plant, not have to endure an unnecessary stop, unnecessary search, or unnecessary seizure or detention. Excuse me. Yes, and our final, I'm hearing a comment. Is there a comment?
I just want to clarify something that if a person is stopped with a drug or a product, irrespective of whatever dosage form, because that person will have a prescribed product, it will have a label on it, identifying the pharmacy, the doctor that prescribed it. There's a little label that once it is dispensed from a pharmacist, it must carry, by laws of Barbados, that information on it. And just how you walk about with pethidine, any other narcotic, if you don't have a prescription for those things, the police can stop you seeing it.
Right. We understand that. However, the bill itself does not speak to that. The bill itself does not speak to it, and to the extent that this bill is speaking specifically to those things, and we recognize that it's very general, and we recognize that there is a plethora of regulations that are supposed to be coming in support of this bill, we would have expected the kind of labeling in addition to what is already prescribed by law.
No, you won't have that, and you don't need that.
Well, again, that's an area of
Huh? Oh, sorry, sir. Through you, Chair, if I may.
Yes, you may.
I think the group has made some excellent points, but we must also, very importantly, remember that no law stands in isolation. And as was previously indicated, there are already existing things in place that will adequately ensure that this person is properly identified. All our policemen know the law, and I don't think these people will be stigmatized or harassed, because the law adequately already makes provision both for their identification, both for records to be kept, and for the person, as you indicated, to be properly identified by the packaging they carry. If you don't have your driver's license and a policeman stops you, you have time that you can produce. If the police needs to make further investigation, the law also provides for that. We must remember that the law, no act, no regulation, no order stands on its own. We have laws of Barbados, not a law.
That is one of the difficulties I had with the bill and the mad rush to get it passed. Because these members of the Bar Association would not know what is in your minds and what will be in the regulations when you get to them. When we bring these things to the public, we should have a set of regulations, and we should have the act in place, because people would not be aware what the full law will be saying. You know, trust me when I tell you that, because he's saying that it's going to be labeled, it's going to be this and that. I took pethidine. I used to put some in a bottle and some home, just in case I rush out. So tell me, now that if I had the pethidine and the unlabeled bottle, police will hold me and carry out. So we need to know what the full extent, what are the regulations, what are everything that is going to be turned out with this act, what the regulations, not for a committee sometime after the fact to recommend regulations to the minister for the minister to approve. That, to my mind, is nonsense. They cannot be aware of what you contemplate. When you ask them to make a submission, you should make them a submission on what you propose to put in place, not what you give them, and hopefully they will somehow magically assume the rest of knowledge.
Senator Haynes.
I'm not Senator Haynes. Senator Maynard. Section 29(3), I felt as a doctor, I provided information that was needed for a patient who was carrying medical cannabis. Section 29(3) of the bill has a section states that under normal prescribing conditions, the information you write on the document would cover someone who is carrying medical cannabis. I felt that was quite clear.
Just to be clear, Senator Maynard, the paragraph, the clause that you're referring to is 29.3, upon dispensing medicinal cannabis to a patient, the pharmacist shall ensure that the label, right? Our view on that is the labeling of the product is not sufficient to identify the caregiver or patient. It's not sufficient to do that, especially if you're criminalizing using language like using a person who is authorized to use it without specifying how you are shown to be authorized to use it. If you are not, the issue is identifying this person outside of the label. Things happen. People switch labels on their own initiative. People switch medications to different bottles on their own initiative. Our issue is not that there's no. I'm just waiting for one meeting to occur. Many thanks, Mr. Chair. Our issue, Madam Chair. Go ahead. Yeah, exactly. Right. It would be remiss of us not to highlight that we consider this an issue. We've taken your comments. We will more than likely highlight this in further review and possibly address it in our comments, which, as I mentioned earlier, will be provided in full very shortly and certainly before your next committee review.
Can I say something?
Minister Ford.
I just want to reiterate that under the Narcotics and the Drug Abuse Act, and our forensic laws, the way we dispense medicine, once a drug is in the category of drug abuse, there are certain regulations. But any drug that is dispensed in Barbados, matter of factly speaking, there are certain regulations and dispensing practices. One of them is that the drug must be labeled. And I'm saying that the practice right now, as I speak, is that we dispense, as pharmacists, our pharmacists dispense, medication that is 1,000 times as strong as TH4, or any marijuana that cannabis active derivative that we are talking about. And as it stands, if the police were to stop a person who's carrying pethidine, for instance, morphine, any of the benzodiazepines, any lorazepam, whatever it is, and the person does not have a label on it, the police have a right to question and the methamphetamines, any drug, they have the right, the same right they have for questioning marijuana. I mean, they have to provide the evidence, but the label is on the packaging. So if the label is not there, just like any other drug, I suspect there's nothing different or unique about marijuana. Because it's already in practice. This has to be happening for the time immemorial.
Senator Haynes, you wanted to make a point?
Sure.
Turn off your mic, Minister Ford.
Just quickly wanted to specify a number of things are explicitly stated on the label. So it's not just that the label will say this is medicinal cannabis. It will say this belongs to Crystal Kathy Melissa Haynes, ID number 85 whatever. X doctor prescribed it on X date. It's a 30-day supply. It will be very, very specific. So if an officer had stopped me and I was in possession of X, and X is labeled as currently is the procedure, I would simply pull my national ID out and my driver's license out. The police would very easily be able to verify, well, this package belongs to so-and-so of X date of birth. We know who her prescriber is, and we've been able to match it with the national ID, photograph ID, that proves that she is authorized to carry. So I think that as it stands, considering what is normal procedure for medication, at least from the patient perspective, not so much the caregiver, but for the patient themselves who's bearing, I don't really see that it should be too much of a challenge. Thank you.
All I'm making because you're practicing.
The bar has the floor.
Many thanks. Senator Haynes, in relation to caregivers, your scenario does not completely address their issue. And to the extent that there's no provision in the Act for this kind of identification, we thought it necessary to highlight this issue. And as I said before, we will take it back to our committee for review and provide a fuller comment in our written submission.
Your point is noted. I believe that we can
let you proceed with the presentation. The point is noted. The purpose of this session is basically for us to hear what the concerns are in the legislation so that we can have a discussion on them. So I do recognize the point that you were making. You said you would put it in your full presentation, which we will receive. Continue. with
Chair, to support what I've been saying, what they're saying, this is remedying, right? I have some home and I have some with me. They're supposed to stop my sinuses from dripping. I don't have the labels with me. I have the one with the labels at home. I put some in my bag. All right?
Senator Franklin, we took the point.
good.
We are moving forward.
You sure that I'm not part of it?
See?
Thank you, Mr. Chair. Our penultimate issue is the basis for the recommendation made under the bill. As previously alluded to, the bill allows for two ways by which a person can access medicinal cannabis through a medical practitioner: via prescription or recommendation that use is required. The question in our minds is, what is the basis for providing that recommendation for medicinal cannabis to be used? Is it a high threshold? Is it a low threshold? Are there certain diseases for which use may be permitted immediately? The bill or regulations to the final act should clarify under what conditions the medical practitioner may make such a recommendation and the basis on which it's made. And that actually leads us to our final point, which is the regulations. We've already discussed that the bill is very broad. It's technically the skeleton by which the regulations will provide a lot more fuller details on dosages, amounts, quantities, potency, etc. And this is demonstrated by the detailed list of potential regulations outlined in Clause 42. And we understand as lawyers that this will allow for flexibility and allow our standards for the industry to adjust according to technological advances and to adjustments in the market. We would, however, again caution that the bill, because the bill is very broad, the subsequent regulations will contain more precise particulars on conduct. And given the criminal penalty attaching generally to the use of cannabis and possession of same, the general public should be aware of at least the basic regulations that will be coming with this legislation. Some of us are and some of us aren't. I believe that in another forum with another presenter, there will be more discussion on the educational programs that will be implemented to ensure that the public is kept up to speed on the uses of marijuana, cannabis, etc. However, we do think it's within our remit to outline that these are issues that were highlighted in review. We also would like, with the chair's permission, to reserve our availability to reappear if necessary once the panel has had the opportunity to consider our report in full, and we will be so available.
The chair would accept your recommendation to reappear. And we will also be prepared to engage you further on the legislation. What I want to do is open the matter for discussion now, first of all at the level of the Select Committee and then to the general audience. Any matters from Select Committee?
I'm speaking more for myself, but this has been a complaint from others in the medical fraternity, as Ms. Pilgrim, as Ms. Pilgrim had said in one of her last comments, there's a little cloud over prescription as compared to recommendation. I've been reading about recommendation in the US and the Canadian market, and their reasoning behind it, at least in the US, is that in some states it's still illegal. So as the doctor not to be held liable, he or she writes a recommendation rather than a prescription. But at the same time, it's still foggy in my mind, what does that mean? How am I liable with respect to writing a recommendation and the patient does what he feels like with the medications? Basically, how does my butt stand when something like that happens? And it's this is one of the areas I've been hearing a lot of talk with many of the doctors. We are really unsure of that, and legally, what does it mean?
In relation to written recommendations, This is an area that has been introduced in relation to this industry as a result of the fact that prescriptions usually carry a specific dosage. And as a result of the developing industry and the science that is developing, some doctors are not comfortable prescribing. As a result, a written recommendation is given instead of a prescription. So that is where the written recommendation came in, or how it comes in.
That no less is clear as mud to me. You know, I'm confused now, you know, because are you going to tell me that you're going to recommend or prescribe something and don't know how much you're giving the person? That's what you're telling me? So let's say, I don't know much about this thing. As I said, I have never used it. I never tried it. I don't know how much you use. But when I take the tablet, let me take one every 8 hours or something like that. And it's so many milligrams. When you're telling me that you can tell some person that you can give them cannabis and they don't know how much they're ingesting?
The written recommendation, as I said, it would be similar to a prescription. It's just that because it is a developing area, some doctors are more comfortable giving a written recommendation rather than a prescription. It does not mean that the recommendation is just going to say use cannabis. It would obviously have to state how it is to be used and the amount that is supposed to be used. So it would be a lower, let us say a lower grade then of a prescription.
I'm sorry, but usually a prescription
Or a lower threshold.
has that information, as in what you're prescribing, what dose you're prescribing. This is what I'm trying to find out. Give me the dividing line that when if I decide I want to write a recommendation, I can write one. Pardon? But that's a little too foggy for me. But I'm not a lawyer. I don't know. Dr. Connell.
Okay, let's hear Reverend Atherley, leader of the opposition.
Thank you, Mr. Chair. Just to thank the Bar Association for the presentation they made. They've addressed some issues which are of concern to me personally and other interests which I represent. The whole matter as to how we deal with caregivers, the attempt of the bill to what we call officialize caregivers in Barbados. You're running counter to cultural practice in Barbados, which is really ingrained. The whole issue of recommendation, I was confused. Now I am afraid, because that explanation given by the legal people to my left takes me beyond the point of being confused over this matter of recommendation, brings me into the realm of trepidation, because what I seem to be hearing is that doctors, we're borrowing from a jurisdiction within the context of which doctors are afraid to prescribe and therefore would recommend. And because of their uncertainty in this context of a developing science, we're prepared to expose the Barbadian public to a developing science which allows medical practitioners to recommend. That is really disconcerting. It really does underscore the importance of the exercise that is now ongoing, and that long ago these matters should have been put to the public and to institutions which are pertinent to the development of this industry so that we could be properly advised by them. So I'm quite concerned when I hear this explanation or recommendation, and I also have some concerns, as have been outlined by the Bar Association with respect to a number of the things that they may, but I guess I'll get the opportunity to speak to them.
Sure.
Let's take Dr. Connell.
Or Dr. Connell.
Thank you, Chair, and good afternoon to the Select Committee. So my name is Kenneth Connell. I am a full-time lecturer in clinical pharmacology with the University of the West Indies, and I am speaking to you in my capacity as chairman of the Drug and Therapeutics Committee of the Ministry of Health and Wellness. Of course, I am a practicing physician and internist, and therefore there, you could say that carry some bias of Western medicine. So I want to address specifically the recommendation terminology. From the experience that we have had in the training of healthcare professionals, for which the university has trained just about 125 plus doctors and pharmacists, this is going to be an issue. Simply because there's a discomfort in writing the prescription in itself, for let aside a recommendation. And there are probably reasons for that. One is that doctors are not usually comfortable in prescribing a new drug, whether it's a cannabinoid, whether it's a new aspirin. As long as it's new, there's trepidations. Coming out of the workshops, what I gathered around the room is many people said to me, well, when we were writing our first prescription, can we call you? So that there's that level of discomfort. Now, the recommendation is almost, I can only see it being more uncomfortable for a practicing physician. Now, it is not to say doctors do not write recommendations, we do, but it is not characteristically written for medicinal products. Doctors write recommendations for exercise. I write recommendations for salt reduction all the time because they're not written on a traditional prescription, but a recommendation for a drug in our jurisdiction is usually a prescription. And I think that doctors feel that this gives them some kind of legal support by writing a prescription and by writing a recommendation. As my colleague, Minister Brown, stated, they have no grounds to stand on.
Can I respond?
Minister Ford?
What?
Minister Ford.
Casual being naughty. Right, I just want to say that over the years, and Dr. Brown and Dr. Connell, and obviously Dr. Warner here can help me, doctors have written not only prescriptions but written orders, which are not prescriptions, which have no legal basis. And patients collect these medicines, which is similar to recommended. The same thing that's written on the slip, it doesn't have a prescription, it doesn't write name, I mean, it just have the name of the patient, but it doesn't have prescribed dosage or anything, and that is taken to the retailer so that he get their medicine. The wholesaler, well, the wholesaler. What I'm saying is that, is this not uncomfortable? What legal recourse do you have when that's done on a written order?
Can I respond to that, Chair? So you're referring to you're referring to what's commonly called a purchase order, a procedure that I am often very uncomfortable doing, because what is meant to happen is that you write the identity of the drug. You cannot write a dose on the purchase order. The patient is meant to take it to the retailer and bring the drug back to you, which never happens in practice. And that's why I don't like that process. Now, it usually means it's a patient who has been prescribed this drug previously. They know how to take it. They've done it before. They've had previous prescriptions, and they're getting a purchase order for other reasons, and therefore they already know. So there's almost an understanding that the patient knows how to take the drug already. But take, for instance, if that person were to be pulled over, what do they have as proof that they was prescribed that drug? And I just want to respond to my colleagues on the left, my legal colleagues, not medical colleagues, by stating that the degree at which law enforcement checks this is at a higher degree than you would think. So I have been called by the police station asking, did you really prescribe this drug, and can you cross-check the dates for this patient, because it was a narcotic. So that check does occur. I also advise patients, especially those who are traveling, to travel with their medication in the dispense container, because it is a legal requirement. You're not meant to be transferring drugs to other containers, as convenient as it might be, to travel with the dispense container. Thank you.
Any other comments from Select Committee?
If I can, let me defer to my learned colleague.
Thank you, AG. Thank you, Chair. I, just in the interest of clarity, recommendations would obviously be used in a situation, for instance, balms, things that are tinctures, oils, not necessarily pharmaceuticals that have a specific dosage. So it is, as the AG would have said before, it has to do with specifics as opposed to just be doing something that is willy-nilly. It is not that we're doing something that we're trying to implement something that cannot be controlled. We are. But you do have medicinal products that you cannot necessarily prescribe according to how a prescription would read. I don't know if that makes your mode any clearer.
Chairman, if I can, and I appreciate the challenge that we face. If Senator Franklin would give me the floor and stop encouraging the smoking of spliffs, I'd be glad. There are police officers in the room. There's a cultural context, though, to what we're talking about, and we relegate these things into tales of our past. I don't know that my grandmother could ever make the same batch of bush tea the same way twice. Nor remember exactly which bush she used on occasion one or number two. But somehow or another she was confident that it worked. I suspect that I'm evidence that it hasn't. But the point though is that from what I hear, and I have no personal experience with it, but from what I hear, there are individuals who have cancer, who have HIV, who have a number of ailments, and they swear by the use of cannabis for one purpose or another. I feel it is my responsibility as a legislator and as a policymaker to put a system in place which allows all Barbadians to benefit from whatever opportunities there are for health care that might exist. I accept that there might be a level of precision that might not be available to us. But if I were afflicted with cancer tomorrow, and I understand cancer is one of the things, I would not want to know that my ability to find palliative care in cannabis is thwarted because you, Dr. Connell, or you, Dr. Brown, or you, Dr. Booby, have a problem in determining whether it is to be oils, or to be smoked, or to be capsules. As a sick person, I have one focus, and that is how I can either reduce my discomfort or ultimately find healing. And so while I understand the scientific challenge that you as a person trained in Western medicine is faced with, if I have back pain and I go and find relief from acupuncture, is it not better that I find relief than that I should worry about the route through which that relief is found? Now, I think we all know of enough instances in the Barbadian context where individuals have been ill, have been suffering from one ailment or another. Some instances have been very well publicized. And I believe that the general public sentiment is that those persons should be given assistance where they can. And as I suppose the chief law officer of Barbados, I would have great difficulty feeling that it would be right to charge an individual with possession of cannabis in circumstances where that person makes a sound, conscious decision that that is where the medical treatment lies. Now, being policymakers is never easy. We have to walk that tightrope. Is it better to say because recommendations lack the specificity that you are accustomed to, and therefore you should throw it out? Or is it better to say that there are circumstances where you are satisfied that your patient would be better served by having it, but you acknowledge that you simply cannot tell him how many micrograms of it to use because there is no scientific indicator of how many micrograms to use. We were told earlier that as a doctor, your mantra is first, do no harm. I would like to think that the second part of that is, secondly, try to help where you can. And to reduce it to a pure scientific distillation of, I will not get my patient to use it because I cannot tell you exactly how big the pill is supposed to be, I'm afraid I would switch my doctor.
Thank you, AG. And I am in complete agreement with your statement, except to say that this is the current status quo in medicine. We quite often cannot precisely prescribe a milligram dose, and we say apply Voltaren cream to the affected area liberally. I mean, as to how much Voltaren cream that is, you know. So, but it depends on the route of administration and the type of drug. For drugs that have a very narrow therapeutic index where you're worried about harm versus good, then you want to be a bit more precise with those drugs. Now, to respond to your example of a patient coming to a doctor and the doctor is trying to decide what route to take, and I don't really know which route to take because I don't really know how much to smoke. I think that should be shared decision making between the practitioner and the patient, and who should then decide on, well, I think the oils are available and here is the evidence and this is why I'm going to prescribe the oils, or I think this is, or recommend the oils, this is available, and how do you feel about it? Because ultimately it's the patient's decision. But you are correct in stating that it is quite often not possible for us to state precisely what dose to give. But for instance, to a counter argument is we would never write in a prescription take some morphine because of the potential for abuse and harm.
And, well, Dr. Connell, I think that this legislation, therefore, Dr. Brown's concern is, well, where does my butt, quote unquote, stand in the middle of all this? It is protected by this bill, which gives you the opportunity, if you determine that your patient should have the benefit of a cannabinoid or cannabidiol, whichever it is. If you should decide that your patient should have the benefit of medicinal cannabis, then this bill empowers you to make a recommendation which doesn't carry you to the precision of a prescription because you don't feel comfortable doing it. But at least it allows you the opportunity. It doesn't direct you to do it. But if you should decide that your patient with cancer or one of those other illnesses would benefit from a cannabis compound, then it gives you the opportunity, doctor, to be able to lawfully give an instruction to a pharmacist, please dispense this compound to my patient.
Having a prescription also allows that, sir. So
it does, except that you may feel that you are not able to prescribe. Now, if you say to me that you could prescribe marijuana to a patient tomorrow, then I don't have a difficulty.
The issue is, I think that the recommendation raises doubt in the mind of the prescriber, and that is the problem, and you don't want to raise any doubt in a cohort of prescribers that are already concerned about prescribing a new drug. If you just state you need to write a prescription, so you have to come down on a diagnosis. Two things in medicine: you have to decide on a treatment, and that treatment has to be clearly defined. Now, that doesn't have to mean a precise dose, but you should be able, for instance, to say, I want to prescribe X drug as X number of whatever, leaves or whatever, for this condition for X period of time. And that should go on a prescription.
Well, sorry, I don't mean to monopolize the forum, and I don't want to put you on the spot, but do you think that there is a reasonable case, not necessarily a good case, but do you think there's a reasonable case for the medical field to prescribe cannabis to a patient?
I think there's a reasonable case if the evidence is available for particular products. So you can't generalize and say...
Agreed.
Yeah. So
Agreed.
For particular products, as would be done for any drug, for instance, you're not going to say, is there a reasonable case for insulin to be prescribed? You're going to take what type of insulin, how is it administered, those kind of things. So To generalize cannabis is impossible to respond to.
I accept that, but assuming that those parameters are met, that you know you've diagnosed, and whatever other things go through your
With doctors,
expert mind, right?
Yes.
Do you think that there's a reasonable case for the prescribing of cannabis compounds?
I think those that are scientifically approved, yes.
Could you help us with which ones are scientifically?
There are 5 products that have been approved based on the evidence available. The Drug Formulary Committee has approved 5 products, and those are the recommended ones. Now,
Tell us what they are, please. And I don't, if you tell me something with 12 zeros and some H's and so on, I can be lost.
no, but they're long names. So there were some products described this morning. In fact, my recollection was that all the products were described as synthetic. All of them are not synthetic. Some of them are purified natural forms. There are the nabixols or cannabidiol, as dronabinol or Sativex is the term, the brand name used. Then there is purified cannabidiol oil, which is a Pediolex, which is a drug used in a very rare pediatric disorder. And that is a purified form of the drug, of cannabis, of CBD, THC. This is another correction, that the drugs that are approved are all CBD compounds. That is incorrect. Some of the drugs used have THC. The THC component is necessary in the
Dr. Brown clarified that this morning.
in the endocannabinoid system. Then there's a synthetic non-psychoactive cannabinoid, anabasum. This was approved for use in dermatomyositis, a rare skin disease. Synthetic cannabinoid capsules, nabilone, and synthetic cannabinoid capsules, Marinol. The difference between nabilone and Marinol really deals with their strength. One is a much lower micrograms, the other is in milligrams, and these are used for nausea and appetite stimulation in terminal illnesses such as cancer and HIV. And this is not to say that if the committee tomorrow, because we meet tomorrow, we were to receive an application for cannabinol oil X, we would not look at the evidence for that drug and make a decision. And there's always the perception that drug formulary committees hold drugs up to a very high unrealistic standard. And that is not the case. The drugs are taken as a case-by-case basis. Some drugs you cannot hold up to a large randomized clinical trial because there aren't as many people affected with the disease, or the drug is illegal, so you can't really test it to that level. We follow the principle followed by the Food and Drug Administration, and that is that a reasonable level of evidence is available for the indication that the drug is being requested for.
And I'm sorry to unfair you. I yield to you. Okay, all right. Visitors come to Barbados and they bring with them their extracts and compounds and oils. And my understanding of it is that they require a particular fiat in order to be able to come into Barbados with those drugs. Now, one assumes that that particular medication would have been prescribed wherever they came from. Correct?
Or recommended.
Oh, fine. Well, good. Okay. Now, when that person arrives at Grantley Adams International Airport with this particular thing, do you apply your standards or do you accept the standards that were set in the jurisdiction that they came from?
So good medical practice would require the physician, if he's going to recommend continuation, that he accepts the care as appropriate. Quite often I see patients come in from overseas and I switch their care because I don't think it's the appropriate care that they're on. And I do so as a joint decision making with the patient, but I say I'm not going to continue drug X because I disagree with your physician. So that happens, and if I disagreed with the physician in this case, yes, I would stop the drug. And if I agreed, I would continue it.
But in relation to a cannabis compound, have you had experience of a patient coming in with a particular compound and they need to get it in? I mean,
I haven't. I have spoken to colleagues in anesthesia, for instance, who have had similar situations. I wouldn't state what the advice were to those patients here, but although they haven't rewritten a prescription, they have, I guess you could say, recommended that if the patient wants to, on their own free will, continue, they should continue.
But that's not of their own free will. Wherever they came from, they had something which
Right.
said you should use cannabis.
The question is, can a doctor in country X prescribe any drug, for instance, that might not be on our formulary, and that patient comes into the jurisdiction? Is that patient governed by which law or regulation? Are they governed by Barbados's regulations for this drug, which is not approved, or are they governed by where the drug was prescribed? And I guess I would have to ask you that question.
Well, you have three able lawyers beside you. I think that we would err on the side of saying that you don't have any criminal intent. Basically, you are using it as a bona fide person who is being prescribed or recommended to you for your medical treatment. So we will have to decide if we want them to come or don't want them to come.
Well, the truth is, under the current bill, the definition of visitor makes their access to medicinal cannabis in Barbados accessible only via a local doctor. The regime is not completely specified in the legislation, and it's actually alluded to in that very broad section at the end, section 42, which speaks of subsequent regulations to be put in force. So there is a separate regime contemplated by the bill, for visitors' access to medicinal cannabis in Barbados. We just don't know what that is at the moment.
Thank you for clarifying, and through the chair, my final point is in response to my colleague. So this is not unique for medicinal cannabis or its compounds. Visitors come to Barbados on various forms of medications that are not available in the island. And whether the doctor agrees that they should continue or not, it's irrelevant because the drug is just not available here. And safe transition has to occur, and doctors have to feel comfortable in converting patients to a locally available drug. There is also the issue of antidotes and prescribing a drug in an environment that is not equipped to deal with it and its side effects. And that may be an issue to consider as well. For instance, if a person comes in on drug X, I would use an example of a common blood thinning drug, Pradaxa, and we didn't have the antidote. Here, doctors might say, well, I don't feel comfortable continuing Pradaxa because there's no antidote. We're going to use old-fashioned warfarin because we can give you vitamin K.
Leading on to that, I read maybe legislation for one or two territories. And one of the things that concern me is that there is a defined list, Dr. Connell, there's a defined list of diseases/ailments that marijuana on the books is recommended. My concern is, are they going to be listed, even with amendments later, are they going to be listed on the bill? Or is it going to be left up to the medical practitioner to decide which diseases he or she thinks? Because we already know, for instance, in my world, I'm not sure what this says, I forgot, that medicinal marijuana is to be used, for instance, when all else fails. Like sometimes, like the nausea and cancer, for instance, correct me, Dr. Connell, if I'm wrong, but there are other drugs that are equally good or better. Are we going to list the diseases on the bill so that we are clear what we are using the medicinal marijuana, or is that left up to the doctor to decide, oh, her knee is hurting, I will give you medicinal marijuana? This is one of my other concerns.
So the Drug Formulary Committee, when we were tasked with this, made a clear recommendation that it be disease-specific or indication-specific. You have highlighted an important point why that was the case, and that is, for instance, pain management, there's a stepwise approach, and the cannabinoids are not step one of that algorithm. And you would not want a patient to come to a doctor saying, I have a headache, and say, oh, well, let's try this medicinal cannabis compound. You would want them to start with paracetamol. So, and even in that workshop, several misconceptions about what should be step one versus step two, step three came about. So you had prescribers who were uncomfortable as to where this drug should enter the algorithm. So in response to your question, I think that yes, it should be disease specific, and there should be clear algorithms that prescribers should follow. This would not be in any way perverting how medicinal marijuana is prescribed, because this has been done in several new drugs when they're introduced. There are clear algorithms. As prescribers get more comfortable, then you relax the algorithm, and then eventually the algorithm is removed.
And that would be your recommendation?
That would be my recommendation, yes.
Any other comments from Select Committee?
Just one quick comment. Ms. Pilgrim from the Bar Association had pointed out earlier the challenge with the age group, young persons. And I just wanted to highlight something I noticed where a person age 18 or older, that is clause 28.4, it indicates that a person who's 18 or older can be a caregiver. So it's just interesting that as a young person, your mom or dad or guardian had to sign for you. That's between 18 and 21, but you could still be a caregiver. So I agree with you on that one for sure. And I wanted also, I mean, you might not be prepared to speak to it today, but if in your final written submission you could include just some of the possible medical legal issues that medical practitioners might, come. That's always a big issue for us, particularly with something new. Some of the considerations that should be made for us as doctors in terms of medical legal challenges, just so that we could maybe consider working that into the final bill. Thank you.
My final sentence in one of my notes is we should definitely collaborate with BAMP on some of these issues. So,
Mr. Chairman, on the matter of regulations, Senator Franklin has spoken quite stridently about the absence of regulations at this point, and the bar is also concerned about it. Let me say, though, that there's a built-in agenda to this particular bill, and regulations actually finds expression in clause 42 of the bill, 42, 1, 2, 42, 2, and 3. And it does give a fairly clear vision as to the areas that are going to be regulated. And I think that the bar, the public, the medical profession, the pharmacists should take comfort in the fact that we have gone to the trouble of stipulating the areas that are going to require specific regulation. Those regulations are already under draft, but I'm happy to say that this process will help to inform some of that work. But this is a fairly clear indication of the areas that we're going to provide regulations for. So you should take comfort in that fact. And that includes labeling of drugs, cannabis drugs.
Mr. Chair, Ms. Pilgrim, is it? Ms. Pilgrim may take comfort in what was just offered by the Attorney General. I don't. And this was a matter I was going to raise when the committee in-house looked at this thing more specifically. But I think this issue, the attempt to establish this industry in its many aspects, is so important, and it's such a cultural shift in the way we do business in Barbados, in both the health sector, agricultural sector, import, export, that we need to see those regulations before we proceed down the road with this bill. And I do not know what is the haste. I've already made the point that in the House of Assembly we have conceded that haste was required with reference to many important pieces of legislation under the influence of external institutions. We have acceded to the wishes of government in supporting the government to have those bits of legislation passed through the chamber with the required haste. I do not know what is the haste attaching to this one, and I believe that the regulations will be so important as that the passage of this bill should not so far proceed the scrutiny of those regulations. I want to make the point here today because it was just raised and because the Attorney General just attempted to offer us some comfort. But I was really going to reserve that input for our in-house discussions. Mr. Chairman, I think that is extremely important. Usually the devil is in the details. And also regulations don't normally, in the course of our normal parliamentary procedure, come to our attention in the same way that a bill will. And they could quite easily pass before us without notice. But these are extremely important.
If Ms. Pilgrim may respond to the Attorney General, we have acknowledged, the bar has acknowledged that the bill is very broad. It's skeletal, well, not skeletal, but it provides the inner core to which the regulations will be added. And that is, from a drafting standpoint, absolutely critical because you cannot or should not be expected to list every minute detail of what could be in the regulations into the primary legislation. Our only concern is, well, one of our concerns is that, again, given the criminal penalty that attaches to use and possession, the general public should be aware, at least of the basic regulations that will be brought into force with this legislation. And we have also acknowledged that this will give the legislature the flexibility to augment or modify the regulations in accordance with market shifts and technological advances. From a purely customer service point of view, there are clients and investors and users of the system that do need clear guidance on how this the framework, the regulatory framework will be established just for their own investments and their own expenditure. And they have a strong interest as well in this legislation and ensuring that it has a strong supportive framework.
Thank you, Ms. Pilgrim. We acknowledge the concerns about the regulations and your recommendation of having the recommendations available is noted. I do also note the concerns shared by the Leader of the Opposition with regard to the regulations, and we will endeavor to proceed by paying attention to the recommendations given. Dr. Brown?
Thing of concern, the Attorney General had explained it to me as best he could, but there's still concern among the medical fraternity and pharmacists, not necessarily including Minister Ford, that there is unclear as to where the Ministry of Agriculture begins and ends, as opposed to the Ministry of Health. I am seeing in some jurisdictions that the health part has actually been left to the Ministry of Health. There is worry that even, in my opinion too, to some extent, with the drug service, they are concerned, the individuals that may work in the drug service or in pharmacy, they are concerned about the jurisdictions. In other words, basically where they end and you begin, why couldn't this be put away from agriculture? For Israel, instance, and under correction, I'm seeing Israel, for instance, has the medical part under their own bill in that responsibility. I'm just unclear as to why it has to be here. I was given an explanation. Please remind me of it if you have it. And that is it from me for now.
Well, I don't know what explanation you were given, so I can't remind you of it. But what I will say to you is that because of the fact that what we are developing an industry where we are starting from seed. Once you're starting from seed, then that is agriculture. Once you're engaging local farmers to participate in the building of an industry, that is agriculture. We did, and perhaps the Minister of Health and Wellness and I would have to then settle again on a final position where this is concerned. Because I do recall that in previous discussions, what we did agree to is that the Minister of Health has certain powers to trigger the use of the drug, and that the minister will have used those powers for the formulary committee to determine use, and that they would have proceeded ahead of agriculture, which did take place. And that was a matter that was brought before the cabinet and agreed to. But the seed to final user is where the Ministry of Agriculture would take the lead, because this is all about farming at the end of the day, cultivation. You don't get the plant, you don't get anything without the involvement of agriculture.
Thank you, Chair. Let me assure you, Dr. Brown, that during the initial stages in terms of the preparation of this bill, the Ministry of Health and Wellness shared the concerns that you are expressing. And we met with the drafters. It was a very intense meeting. And we are assured and we are satisfied with that assurance that certainly all of those issues that are regulated at the moment, that are within the law in terms of the Barbados Drug Service Act and the Health Act and all of those things, that is the law. You can't just dispense the law like that. So all of the responsibilities that exist under the current laws in relation to the Ministry of Health and Wellness, those will continue.
If I may, Chair. For instance, I'm looking at the record keeping. Why is it that a medical practitioner, for instance, should submit information? I know you excluded a lot of things now, but why should a medical practitioner submit information to a Ministry of Agriculture with respect to the users of medicinal marijuana and caregivers as opposed to the Ministry of Health?
Well, it's not specific to the Ministry of Agriculture. There's a Barbados Cannabis Licensing Authority, which will be the entity responsible for managing.
If I can, look, I'm sure there's a lot of turfism and so on knocking about in the room, generally in the halls of government. Yes, the keeping of turf, and I don't mean grass, or grass by any other name. But let me just say that there are some realities that the Pharmacy Council, I'm sure, requires documentation to be submitted to it. Okay? And perhaps BAMP requires documentation to be submitted to it. But they're not treated as being mutually exclusive. Each agency requires information to be submitted to it purely for the limited purposes of its remit. The Medicinal Cannabis Authority has the responsibility for monitoring the cannabis from the time it gets put into the ground as a seed until the time it is consumed by an individual as an end user, from start to finish. And the reason for that we already know quite well. It is because the possession of cannabis under our current law makes you liable to a criminal offense. And, someone talked about the level of fines and so on. We have to remember that under the law as it stands, we still have to abide by our international obligations. And it is for this reason that we have to make sure, not just Barbados, in Jamaica, in every country in the world that has a medicinal cannabis industry, or every country that we would want to follow, there are special security arrangements put in place, and I mean, they even tell you the kind of vehicle you can transport cannabis in, because the imperative of the regulator is to make sure that medicinal cannabis does not find its way into the stream that is considered to be illegal. Plain and simple. With that in mind, it is therefore important for the Medicinal Cannabis Authority, as part of its monitoring process, to make sure that it knows what is produced, what is prescribed, so that they can be satisfied that which is medicinal stays within the medicinal stream. plain and simple, and that's the only reason for it. But it is not a case where somebody is trying to take over the role of the supervisory role of BAMP or the supervisory role of the Pharmacy Council. In fact, we have tried to limit fairly severely the information that is to be provided to the authority, and it's just really to regulate quantities.
If there are no further comments from the committee, I would want at this point for us to take comment from the audience. Ma'am, you're free now to come to the microphone, give your name, and make your comment or ask your question.
Dr. Roseanne Blenman, former Merck biomedical scientist. The reason why I rushed from dropping my daughter off at lessons and came here today is because I've been following you all morning and all afternoon on your live streaming. And I wanted to, first of all, thank you for bringing this bill to the floor. I think it's a very timely discussion, especially as you bring it to the people so that we can give our input and express our concerns. As a biomedical scientist, though, currently living in Barbados, I moved back recently, I felt that I needed to come here to give a perspective that would be, I think, very different from what you've heard today. I made a few notes because I tend to be a bit long-winded, and I wanted to touch on 3 main points. The first is that I believe that as a government, if you're looking to develop an industry that touches, as you say, on agriculture, it touches on health and wellness, it touches on import, export, so it touches on many different realms, as it were. There are a few things that, in my humble opinion, need to be considered. And I think that I should also say that I think Barbadians are brilliant people. So I'd almost like to challenge us to elevate our thinking beyond what we see in Europe and what we see in the US with what they have done with medicinal cannabis and take it to the next level. I think this is our opportunity now that we're here. Okay, so we're not saying we might or might not legalize. We're here because we're doing it, and our next step is to do it as best we can. So the 3 points that I think most relevant here are the value of the data, value of big data. That's the first one. The second would be the devil is in the details, and the third would be let's not go back to slavery or agricultural colonialization. Okay, so I'm going to start on the first one. This cannabis bill, as I've read it, and I read the whole thing, it's available online. Download it, read it. I mean, most of the people in this room are all learned and very well informed. It's very obvious. But I think to the average Bajan, it's important that we all have our say, and this is why this forum exists. But it's also important that, you know, we live in the information age, so let's consume the information and make good decisions, because this is where we are. We want to make a good decision. So this cannabis bill speaks only to one type of data that I can see. It's a tracking and tracing type of data, and it tracks and traces the cannabis and the user. So I want to ask you, as the government developing this bill, why are we not collecting data intended to drive this Bajan industry ahead of our competitors? Because let's be real, this is a business, we've got competitors. We need to establish ourselves at the forefront of this industry. And the way we can do this is with big data. So why do I say this? We employ big data tools to catapult us to the forefront, given that we are entering an industry that is decades old. This is not new. Medicinal cannabis is new to us, but old to the rest of the world, okay? So we are entering at a time where we are saying, let's go for medicinal cannabis when everybody else has started to decriminalize marijuana. They have legalized recreational marijuana. And so what is our plan? Okay, what is our plan given that we are decades behind the rest of the world? And the rest of the world, they're our competitors. Now, I guess, okay, that there will be no real significant earnings through the taxes on the cannabis sales and through the licensing fees if we cannot figure out a value proposition that will make people leave their countries where marijuana is legal to come and buy ours where they need a prescription or a recommendation. Okay? So I think the conversation that we should be having, one, is how will we use the tools that we know are available currently to catapult us ahead, given that we are entering this industry decades behind. So that's the first one. We can't use a decades-old approach and just do track and trace. Our only option is to disrupt this industry. And when I say disrupt, we absolutely need to push the boundaries of data and science to bring innovation to Barbados and make us number one. That's the first thing, big data. The second, the devil is in the details. Now, the US Surgeon General doesn't recognize medical marijuana as medicine because there is no proof of its therapeutic effect. Now, for those of you on the committee here, you all know this. This is not new, this is old. But for the average Barbadian, okay, you need to know that within the scientific and medical community, our proof is mostly anecdotal or say so. That's what anecdote means. It means because I say so, it is, okay? And for the last 50 years, there have been no major clinical studies designed to garner an understanding around marijuana's mechanism of action, its effects on certain diseases, its proper dosing, its side effects, its safety profile. But what I want to ask you today is why must we as Bajans wait on the US or Europe for its brand of science? And why are we assuming that Bajan scientists have nothing to add to the global conversation on the efficacy and safety of marijuana? So I don't see that this bill is currently opening any doors for local and regional scientists to have any impact in this poorly understood field. Now, this bill also, for me, has not addressed a lot of the details. And I've heard repeatedly that, the Bar Association wants some details. The medical fraternity wants some details because everything's a little bit too gray right now. And I think I 100% agree. So questions that for me would need to be answered. And once again, this is my opinion as a biomedical scientist who worked in pharma in the USA. What forms of tetrahydrocannabidiol, okay, THC, and CBD are allowed? Are we allowing what types of formulations? Dried herb, pills, oils, whatever. These types of things to me need to be there so that you have shown that you've done your due diligence. It's not just a willy-nilly bill, okay? Are we allowing enhanced foods? Can I brew a THC-laden beer and put THC in popcorn? Can THC, which we all know is the psychoactive component that is attributed to the addict-forming nature or tendencies of this drug, can I enhance food and drink with this? Is it okay? So I'm asking that the bill address this and be very specific about it. As far as CBD goes...
I am hesitant to cross you. But I have to draw to your attention that when you allude to things like brewing a beer and those kinds of things, you have crossed the threshold between medicinal cannabis and recreational use.
So
and hold on, and we have the doctors who have made it very clear that the dosage regime that they want to follow, they not able to prescribe or allow for anything under medicinal cannabis that is brewed in a beer or put in a cookie or anything like of that sort, or popcorn or anything of that sort. So you're really now crossing over to the recreational use of cannabis. And I find that this is a conversation that needs serious managing. I do take your point, and that is the reason why we stated up front that Barbados will become a center of excellence for research and development. And that will involve big data. And the reason why we said that is because we are working towards a unique cultivar, which puts Barbados, when the industry goes this way and starts to decline, we hold a unique position. And I would have been happy to hear you repeat that part of my presentation, but you didn't, and I just would happy to clarify for you that what we are saying we're using our soils, our water because of our cornerstone. We're using our trained people, and we're moving to a center of excellence for research and development where we can give Barbados a unique proposition in terms of the industry.
Okay, so thank you very much for your response on that one, but I think I want to be clear that this is just my response to the bill, not necessarily any of the presentations that have been given in this room, because my thing is, it's one thing for any of you, regardless of, you know, where your station in life is, to say that this will come. But I want to see it in the bill, because the proof is in the pudding, not necessarily in what we would like to see.
But you would get that in the regulations and not necessarily in the bill itself.
Right, so I actually come to that as well.
I take your point in terms of where you want to see Barbados in an industry that at some point in time when you're jostling for market share, you know that you hold a safe position. I accept that, and that is fully taken on board. But the hardcore reality of it is those things you're not going to see in a bill. And so you're speaking to how we then manage at the BCLA. And you're speaking to what I did put into the presentation when I spoke about Barbados' unique position and developing strains that give us a unique quality brand of medicinal cannabidiol and tetrahydrocannabidiol, which will be used in the industry.
Okay, I'm happy to hear that those regulations would be developed. I'm probably not as happy to hear that we wouldn't see some at least basic or minimal definition to see that you've thought about the components and the potential harm and the potential issues around safety and whatever, and you're dealing with that as a part of the bill. Now, I'm not a lawyer and I don't write bills, so I don't know how much detail you would want to go into, but I do know that there is some detail in most of the legislation that I have read in the United States for those states that have legalized medicinal cannabis as well as cannabis for recreational use or whatever else. So I go on. So I wanted to see something about the THC and the CBD. I also wanted to see what diseases can be legally treated in Barbados. So can I go to a doctor and get a cannabis prescription for pain if I have a cold and I'm coughing too hard? And I go to them and I say, well, I've got a painful chest now and I hear marijuana is good for pain. Can I have some cannabis for that? So the idea that you have looked at what diseases, I mean, everybody knows about the cancer, everybody knows about the very well documented illnesses, and these are still just anecdotal. These are not based on any clinical studies or any real empirical evidence, okay? But I want to see that you've thought about it. And I can't just come up and say, look, my back's hurting, or I have arthritis, which I do, so can I have some 4 spliffs a day for that, The other thing is the idea that THC, with its psychoactive components, can be quite harmful, not just to the individual, but to the society. And so does my cancer-ridden granny get access to a 95% THC-laden vial of vape oil if she's able to access it? What I'm saying is we must define what concentrations are allowed, how regulators will determine and assess purity and concentrations, how the government will assure and control that quality, and how will we ensure the safety of the public. And finally, my last point was on Part 4, Clause 32. And this, this particular clause is supposed to make me excited about being a Bajan, and is supposed to make me excited about the potential of medicinal cannabis in Barbados. It speaks to our ownership rights to this industry, and it speaks to the potential for all of us to benefit from it. But first of all, let me just put it out there that this is how I read it. To be eligible for participation in the cannabis industry, you must be a Bajan, a permanent resident, a legal immigrant, or a CARICOM national who has no history of being addicted to drugs or being convicted of a drug-related offense. That's how I understand it. And I pretty much gave it back just as I got it, but I removed the indentation and the bullets and put it all together, okay? So when I analyze this, you can be a Bajan, a CARICOM national, or anyone on the face of the earth who can afford to buy a resident or immigrant status in Barbados, essentially, because what you're saying is that whoever can be a legal immigrant or permanent resident, we're not counting Bajans or CARICOM nationals. We're just counting the immigrants and the residents now. If you can afford to be a permanent resident, so you pay your fees to immigration.
Sorry, ma'am, immigrant status in Barbados doesn't work like that. So you're beginning from a false premise. I apologize, but
no. So correct me, but I'm saying this is how I understand it. So if you can somehow become an immigrant and have permanent resident status, then you have access to this industry. As well, you can be a company, and 30% of the company must be held by the same, a Bajan, a CARICOM national, or anyone who can afford to have an immigrant status or become a legal immigrant or permanent resident in Barbados. So I think my issue with this is that it's not tight enough. My issue with this is that
can you please point out where it is not tight enough? Expand on that.
Right. So what I'm saying is that, to me, I read that as open access. Let me just say it straight and plain. I don't see that as a protected industry. Just because 30% has to be owned by a Bajan, I don't see that as protected. I see that as wide open as long as you can afford to immigrate here or get through the process. Now, if we move on, to be eligible for a research...
Would you mind if we didn't move on just yet?
Okay, sure.
Let me begin by saying that about 15 years ago, Barbados liberalized its telecommunications industry. And would you like to... Yeah. She's backing up.
My apologies. Yes, sir.
Yeah. When we liberalized our telecommunications industry, we recognized that telecoms had such high entry requirements that the average Barbadian or even the average Barbadian company could not get involved in it. But we felt that we needed to ensure that there was opportunity for Barbadian investment, and therefore we determined that before you could get a telecoms license, or in order to get a telecoms license, the entity had to be owned by at least 25% Barbadian. When we did our analysis of cannabis, and the truth is we've been talking, Ms. Rasimba and others, everybody talked about it a lot this morning. But there are, based on all of the research that has been done, while cannabis, the growing of cannabis can be very much like somebody growing Bonavis or mangoes or anything else, there is also a whole sphere, and you worked in the pharmaceutical industry, and you will know that research and development sometimes requires billions of dollars. The laboratories, billions of dollars. Okay, some of the farms that have been looked at by the various individuals who've actually gone out there and looked are in fact not farms where somebody is growing marijuana in an open field. They're using greenhouse technology, and every single plant is monitored, and that requires, I mean, they say the energy costs of those farms alone are huge. So by insisting in our statute that if you wanted to come from outside and make an investment in our marijuana industry, that you had to have 30% either Barbadian or regional ownership. This is not about selling out our industry to anybody else. It's about recognizing that many aspects of the marijuana industry, the medicinal cannabis industry, will have such high entry requirements that the average Barbadian will simply not be able to get involved. And therefore, what we're trying to do is to preserve the opportunity for Barbadians to get involved. That's all it is.
I think that perhaps that is the premise, but I don't think that the bill, the way it's written, will get us that, because a 30% ownership stake for a Bajan, a CARICOM national, a permanent resident, or somebody with immigrant status does not equal 30% Bajan. It equals anything, any nationality on the face of this planet that can afford to live in Barbados or be here. That's, to me, it's open access. If it said 30% Bajan and 70% could be an investor from anywhere, then that's what you would be saying to Barbados, that we are assuring that every company in Barbados has an ownership stake that is regional or local. But because, and I believe, and like I said, I'm not a lawyer, but I see that as a legal loophole to say that if we can't afford to invest, those companies still come. If we can't afford to have a 30% stake, they still get to come and be here. Because guess what? Any of them can come and pursue some sort of immigrant status or permanent residency here and automatically own it all. But anyway, that's just my understanding, and I'm not a lawyer.
Point of order. The lady is absolutely correct. Section 8, Immigration Act. You only have to be able to have an investment in Barbados to acquire immigrant status. And since then, what government has done, they have been selling status in Barbados. They call it special entry permit, and you pay $40,000 and all kind of stuff to get one. So she's absolutely correct, but it has always existed under Section 8 Immigration Act, where you can purchase your immigrant status in Barbados. So check the act. I was an immigration officer.
Well, I wasn't an immigration officer, nor a lawyer. Anyway, so there's actually more. And this is the part that is actually quite disappointing, I think, because as a biomedical scientist who moved back to Barbados, I am one of those people that gets disenfranchised by this bill. Now, to be eligible for a research and development license or laboratory license, there is absolutely no restriction. None. Read it. There's no restriction. You could be anybody. That's right. Part 4, Clause 32. Read it. No restriction. None. No 30%, no nothing. You can come in, start your research lab or your whatever research you're doing, and you can then, there's none, right?
But ma'am, to be very fair, let's look at the hardcore reality of what is going on here. All right, let's look at the reality of what is going on here. Does it say that if you have the wherewithal as a Barbadian to do all the R&D that you can't do it?
So what I am saying is that the bill sets us up to be
I want you to answer my question.
Oh, well, sure.
Does
You
it say
know
that you
it doesn't.
cannot participate as a Barbadian doing research and development?
It does not say that because it doesn't report on double negatives. It just says what is possible.
So therefore, Barbadians, if they have the wherewithal, can do research and development, and the bill provides for Barbadians to do research and development. Equally, it provides for Barbadians to have 100% ownership without any foreign interference. So therefore, it comes down to the ability of the Barbadian to participate.
Right.
Now, we have said, and I have said, and I want to clarify this because I'm hearing this more than often enough. We have said that through the Agricultural Development Fund, we are making funds available to Barbadians to participate in agriculture, and this segment of agriculture will be no exception. We have also said through the Enterprise Growth Fund, Barbadians are able to access loans to be able to participate. And we have also said that we are going to engage the credit unions in Barbados that are quite liquid to be able to make provisions for Barbadians to have access to finances so that they can participate. Why would we even want to contemplate having a medicinal cannabis industry that is so cornered or compromised that you do not allow for foreign investment to take place when the one thing that drives our economy is our ability to do what? I mean, this is a real situation in terms of gross domestic product and growing an economy. And so therefore, the reality of it is that we have to have a mix of investment. Now, I do take your point that we need to be cognizant of the fact that Barbadians must be given a chance to participate. And that is, I think that point has been made over and over and over again. But my concern is that at times, the conversation is going in such a direction that it is leading people to believe that they are going to be left out, and that is absolutely not the case, nor the intention. So why is it that if you are an investor, a foreign investor, coming to Barbados to invest in a medicinal cannabis industry, that you should not make provision for Barbadians to own 30% of your business? But this is revolutionary. We don't normally do this. We had a sugarcane industry where we planted sugarcane in Barbados. Only certain people participated. We exported everything in bulk, and then it was shipped back to us as a refined product for us to purchase at a higher price. What we are seeking to do here with this industry is to correct all of those things. And so we are at the point where we have said, look, if you're a Barbadian, you can invest. You do have the financial resources. You're free to apply for a license. You will go through the same due diligence check as anybody else, and once you qualify, you have 100% participation. And then we have said to foreign investors, if you come to Barbados to invest in this industry, you apply, you go through the same due diligence process, but you can only own 70% and Barbadians will have 30.
I thank you for that.
Before we go, sorry. Just now he said section 6. It's section 6. And I said she's absolutely correct. Subject to this act and the regulations, a permitted entrant who is likely to establish himself successfully in Barbados in a profession, trade, business, or agricultural enterprise, and has sufficient means to support and maintain himself and his dependents in Barbados until he has so established himself. And it goes on and says, may on application to the minister in the prescribed form be granted by the minister permission to become an immigrant. You don't need 40%, 20%, or 90% because that person can own 100%. If you are likely to establish yourself in business, it says here also, one of the qualifications is if you can establish yourself successfully in Barbados in a profession, trade, business, or agricultural enterprise. This is a means of telling me, this is double speak. You can give me immigrant status and I can have 100%, or I can come in with a whole set of money and I can buy my immigrant status and have 100% because that is what the act says. I am making this up. This is
It's actually there. And like I said, I'm not a lawyer. I'm just a biomedical scientist who read that bill. And all I want you on the panel to consider is that we do have to protect Bajan scientists and local scientists and Bajan entrepreneurs. And we're not just talking about farmers, which is what I get to next. So the mere fact that there are no restrictions for the research and development license or the laboratory license, what I see essentially happening is what the Honorable Attorney General alluded to just now. It takes billions of dollars to do research and development. Let's just be real about it. So when you say there are no restrictions, you open our borders to anybody who has money.
Yeah, we have a comment from the Bar Association.
Well, not to belabor a point, but you said that there would be no exclusion of Barbadians in the involvement. That's not quite true. I did raise the point earlier that persons who've been convicted of an indictable offense would be excluded. And I don't think that's something that should be forgotten, especially in the context of this term, recreational use of cannabis and other attached offenses, for the simple fact that we don't have a legal definition of what is recreational use. Prior to the medicinal cannabis debate that we're having now, all use of cannabis was illicit, period. It wasn't recreational, medicinal, or anything like that. It was simply illegal. What we have now is medicinal cannabis defined as cannabis which is used, consumed, distributed, processed, cultivated, pursuant to a license under the Act. Any other use of cannabis is not described as recreational or anything like that. It's still simply illicit, illegal. That's all.
Senator Haynes.
I'm sorry, Mr. Chair, if possible.
Would you like to sit down?
Crystal, you finished?
Yes. Yes, just a quick comment for the biomedical engineer. I think it's quite easy for any of us to admit that in an island that is 166 square miles with a population of under 300,000, that it would be next to impossible to find access to all of the capital that would be required locally, and also to find access to the expertise. I can admit that I was so heartened to hear of your time spent abroad and your decision to return home. It would be lovely if we could clone you so that we have all of the local expertise available. But I think what the legislation allows for, we can admit this is a novel industry, an industry that because of the prohibition we couldn't have conducted research. It wasn't legal. So because of the newness of it, I think that in fairness, we have to admit that there are cases where we will need the advice and the expertise from the outside, and also, yes, capital from the outside. And I think what the minister has spoken to is an intention to carve out a space for Bajans to have a place. If you have access to the capital and you have the wherewithal to go ahead, set up your research laboratory and build a Bajan Merc, we would be ecstatic about it. But a lot of people might not have access to that and may have to engage a foreign investor to do that. So I think carving out a niche where you can say, well, we want to encourage locals to do their work, but at the same time have a provision where Barbadians still have a place, even if there's foreign investment, is still important. But thank you for speaking.
Let's let the presenter finish her presentation, and then we will continue the discussion. Is that fair? All right, continue.
Mr. Chair, if I just very quickly, if I may, I didn't want to move off of Senator Franklin's point. The provisions of the Immigration Act, there is still a process. I do not believe that it would be correct to say that any form of status is for purchase in Barbados. Senator Franklin is not for purchase. Senator Franklin, in the more than 2 decades that I have been making applications to the Immigration Department, it is a process upon which you pay the requisite fee of $40,000 after you've been approved. It is not for purchase or for sale.
I want to thank you for the clarification, because the information that is being distilled to the public is very important. And I thank you very, very much for bringing that clarity to the discussion.
As an immigration officer, I was offered money to pay, and I refused. I got into trouble. The guy who tried to bribe me, walked away, and I got transferred. Don't tell me it's not there for purchase. I've been there, done that.
I have just one question. Sorry, Eddie.
Yeah, Chairman, what Senator Franklin may be talking about and what is the law of Barbados are two completely different things. There's no purchase of immigrant status by law. If he's talking about someone attempting to bribe, that's a completely different matter. But there's no position for purchase of immigrant status. There is provision, yes, that people involved in agriculture, business, etc., can get immigrant status. But describe it as for purchase, and I believe is by ministerial discretion, but to describe it as a purchase would be absolutely misleading. No, but you're talking about a bribery, and you admitted that that somebody attempted to bribe you. That is a completely different thing, Senator Franklin.
All right, we have heard the Minister of Home Affairs, and we have heard the Bar Association on the matter. And as given the explanation that the Minister of Home Affairs gave and the Bar Association, we will go forward knowing that there is not available for purchase. Ma'am, please continue your presentation.
One question. Before you go on, I just wanted to know, Dr. Bennett?
Blendman.
Dr. Blendman. I could understand her point of view. I'm grateful for it because, as I always say, if I can think about it, the general population can too. So I understand your reservation. How did we come to a 30% ownership of the company? Why not 40? Why not 50? Curious.
Let me say, we started out from the position of our telecoms experience, which required 25% ownership. We felt that the telecoms experience, though, required a far, far higher level of capital input, but that medicinal marijuana could probably bear a higher percentage of Barbadian ownership. But equally, though, we had to realize that there were some elements. I mean, people invest in businesses for profit, and we did not believe that it would be feasible to expect individuals to come to Barbados, make a substantial investment, but be told at the outset that their position had to be a minority position. Whose money are you risking? And therefore, we had to come to a medium position, and we felt that a 30% would be as much as the market could bear, more or less. It would not be so high as to cause a person to feel that their investment was not safe in Barbados. But equally, it would not be so low as to force an investor to attract a level of investment that was not serious. There is no science to it. Perhaps we could have said 35 or 40 or 50, but we knew. But we knew that it. I mean, you know, there are certain commercial realities, and people will invest, but they don't want to and will not likely invest if they feel that their company is by law being taken away from them, and that was the issue. But as I said, we started from the position of our telecoms industry. P.S. Baskin will well remember, where the threshold on that occasion was 25%.
Dr. Bennett is the name?
Blendman.
Blendman. Dr. Blendman, please continue your presentation.
Yes, so when I left off, we were talking about the eligibility requirements for research and development licenses and laboratory licenses, and that there are absolutely no restrictions in that category. I was making the point that anybody could come to Barbados to do research and development or lab research on cannabis, and I thought that that particular element would serve to disenfranchise people like myself and other Bajans, like I believe I heard one of the Rastafari gentlemen this morning or this afternoon talking about his interest in doing research. And the mere fact that we will now be competing against those billion-dollar companies, we've been set up for failure, is what I'm essentially saying. I'm saying that this bill, written by Bajans for Bajans, should not be serving to disenfranchise us, but empower us. And what I see then happening is that Bajans will gravitate to what we can afford. We will be the farmers. We will be the slaves. We will contribute the inputs, while others who can afford the $1 billion produce the outputs. That is my fear. And the way this bill reads, the R&D companies and the research companies will come into Barbados with their billions. They will own the intellectual property. They will sell it back to us. They will sell the products back to us because they will be the ones who can afford to build those greenhouses, while the rest of us are in the fields because that's what we can afford. They will build the greenhouses. While the rest of us are hand rolling, they will have machinery to do it. When they're extracting oils and the components of these plants, I guess we'll be on our kitchen stoves trying to make the best of it and making teas and tinctures rather than the more sophisticated end products. So the idea is that this bill should really be empowering to us, not forcing us to go to the fields and be the farmers. And I'm not saying there's anything wrong with being a farmer, because I understand building a cottage industry, and I understand the value in having 2,000 farmers. But could we also have 2,000 scientists?
and 2,000 entrepreneurs who've not been forced into some sort of minority position or no position at all. That's my understanding of the way the bill is currently written. And so if that is not the intent, please change the way it is written so that you empower us, so that you don't relegate us to being the farmers. Empower us so that we can be the scientists. Put some restrictions, put some subsidies. And if you're saying that, I missed a part of your presentation where you said there'd be loans available. Are there billion-dollar loans? Because Mr. Attorney General said it. It's billions that's needed to develop research and development in the rest of the world. So if you're not giving us billion-dollar loans, then you're going to need to restrict it so that the rest of us Bajans can actually have a chance to do something within this industry. And finally, okay.
If you don't mind, we're so happy to have you that we don't intend for you to leave here anytime soon. From your experience as scientists, what would you imagine the ballpark figure to set up a modern laboratory would be?
In the millions of dollars.
And in terms of the number of skilled scientists that a modern laboratory would have, what would you anticipate? And these are just ballpark figures, back of the envelope. 10 scientists, 20?
To staff a laboratory of that sort?
Well, I was really talking about a research and development facility, not a laboratory, because the laboratories under our regime are more for testing.
Okay.
So let me start over. What would you anticipate a research and development facility would cost to set up?
In the millions, like I said, and you'd probably need a minimum of 10 scientists, as you said.
To start, right.
To start.
Now, you've asked about restricting, and let me say that when we as drafters draft laws, there's a context in which we draft those laws. And we've tried, I'm not offering this as a defense, but just to explain how we've come to where we are. We have received expressions of interest from universities overseas that are anxious to do R&D in Barbados. Now, you can't be a scientist unless you've been an academic. And I think you'd appreciate that in the university media, in order for us to say that a world-class established university must cede 30% of its university ownership to Barbadians is not on. The University of the West Indies, for example, would be interested in doing significant research, but we couldn't say to the University of the West Indies that they should structure or restructure their entire statute so as to accommodate a 30% Barbadian interest. So there are some practical realities that we've had to grapple with. We've long passed the stage where we can bury our heads in the sand and assume that we are going to be able to jump in tomorrow and to do everything that has to be done. It is important for us, therefore, to receive those interests and to allow those interests to come in. But I go back to where the minister interrupted you in the first place. At no point is this, at no place is this bill drafted so as to eliminate Barbadian ownership. And I'd like to encourage you to look at how we've structured it. All of the licenses that can be granted to individuals are open to Barbadians. In a case where a corporate entity is going to apply for a license, you must have regional ownership. We have something called the single marketing economy, and it doesn't allow us to say that something is for Barbadians alone. It has to be a regional interest. And then those two instances, R&D and laboratories, we had to consider what would the specifics of those industries be. Now, it is true that we could have said we will only give R&D licenses to Barbadians, or we will only give laboratory licenses to Barbadians. But I think immediately you begin to recognize that that is not necessarily the best environment to proceed in an industry such as ours.
That's not what I'm suggesting, though.
Good. And therefore, what we have tried to do is to, in every instance, allow Barbadian ownership and participation. But in those two specific cases, if Novartis was coming in to set up an R&D lab, we couldn't tell Novartis that they had to open themselves up to 30% Barbadian ownership. Novartis is an internationally and a publicly traded company.
Mr. Attorney General, if I may, Mr. Chair, if I may just give a brief
University of
response
West Indies.
to the Attorney General on that point from a foreign investment law perspective. It's not the trend in current foreign investment law for countries to give that kind, well, not give, but to restrict access in the way that has been described. In fact, one of the most restrictive countries, China, recently updated its foreign investment law to prevent protective regimes such as forced partnerships with locals and forced transfers of intellectual property. Now, I can't comment on the policy perspective too much because I'm here, yes, but it is consistent with the trend in international law. And I would also just mention on this point that if it is the policymaker's intention to continue with trends on that basis, it could, based on what Dr. Blenman is referring to, investigate avenues where there's not forced transfer of intellectual property rights, but possibly some kind of sharing or requirements for workers, same as in the international business, in the international business sector. So, but I just wanted to make it clear from that standpoint.
I am not at all suggesting that we would require a Merck or a Novartis that we would even insist a 30% Beijing stake in one of their companies. That would be a ludicrous suggestion on my part. What I am trying to put forward here is that with all that you have said, I know that there is an understanding in this forum, on this committee, even within the government, what the stakes are here. So I'm not saying that there is no understanding. I'm saying that because you have this understanding, I believe that you represent us best if you ensure that Bajans, whether they are scientists or farmers, regional people, whether they are scientists or farmers, from one end to the next, whether they are entrepreneurs. What I am saying is, do not disenfranchise us. You know that it takes billions of dollars. So essentially, by even creating this industry, you are opening the doors for these research and development companies, these laboratory research companies, these large medicinal cannabis companies to come into Barbados and dominate. What I am saying to you is that, or at least please consider, crafting a bill where you empower us. And in so doing, you allow us to innovate the industry. Now, if that means going back to the drawing board to see how you can very creatively figure out how we protect IP that is developed here, then please do so. If that means going back to the drawing table to figure out how companies that come here to do research and perhaps use local or indigenous strains and develop from our original seeds and our original pith, our essence, you figure out a way to protect that, then you will be representing us and doing something good for Barbados.
But if it is just that, you know it takes billions. You say there's loans and programs for us, but really and truly, we can only get $5,000 from your program. But you've just admitted that it takes billions of dollars to develop a company like this. Then what you're essentially saying is that for a biomedical scientist like me, I should just go and try to start farming unless I can figure out myself. And I'm not saying that you are closing the doors to people with wherewithal, but let's be real. Scientists in Barbados do not have billions of dollars to invest in medicinal cannabis. Okay? The reality of this situation is that we are opening our borders to conglomerates and serious big business. Okay? We're not talking about little small fries like myself. We're talking about serious money. The potential, though, is that you can protect Barbados. And all I am asking is that this bill thinks a little bit more about how you can empower, because we're not talking about a loan program that's going to lend me $5,000 if I need $1 billion or millions to pay 10 scientists, okay? So if we're real about it, what I'd like to see is some consideration for innovation and empowerment. And this would detail how we would protect our IP so that these foreign entities wouldn't come here, develop our IP, and then sell it back to us because they have the rights to it. It would also detail how Bajans would be empowered throughout the entire value chain. So tell me about when my friends and I get together and start a cooperative and we have our seeds and we plant on our acres because maybe we can afford a little bit more than, say, a smaller farmer. Tell me how you're going to empower us to get from seed to product. Tell me where there's the subsidies for the manufacturing, because I don't want to just be providing the input. I don't want to farm it and dry it and give somebody else the leaves and the seeds. I want to be able to develop an oil that is second to none. As a matter of fact, I want my CBD oil not to be second to none, but to be like nothing the world has seen. Okay, but tell me how this bill would achieve that. And then tell me how local and regional scientists will be involved to take us to that next level.
You have repeated that over and over. I don't mean to cross you.
No.
But you have repeated those same points over and over, and we accept your presentation. We truly appreciate you coming to this session and being able to present your perspective on what the industry should look like. I think you're saying a lot of what we have already said. So I take it to mean that you are basically interested in protecting the rights of Barbadians to be owners in the industry, and that is the general consensus that we take. How we get there, we will determine how we get there. The reality of it is that the whole intention of this industry is for the empowerment of Barbadians, and that is the first thing that we said up front. Now, you are concerned about scientists' involvement. I think we have already made it clear that the Barbados's medicinal cannabis industry will be one where the focus is going to be on research and development, so that we have a unique position on a global platform jostling for market space. All of that I take on board. I take the point that you're making where you're saying do not disenfranchise Barbadians, and we are seeking not to disenfranchise Barbadians, but in fact to empower and enfranchise Barbadians. So I want to thank you for your presentation, and your points have been noted, and we will proceed to other comments. We will take comments in response to what you're saying, and if there are any other comments after comments in response to what you're saying, we would take those.
Thank you very much for hearing me out.
You're most welcome.
Mr. Chair, before I have to take cannabis to relieve a blood clot, I was sitting here for so long, from 10 o'clock this morning. The latest is 10, it's 5 now. I don't think we should go beyond 5 o'clock. We're going to be there already. Because I really don't want to take the cannabis to remove the blood clot. I was telling you. Right? So it's 2 minutes after 5, sir. I think we could save some of this nice thing for another day. I recommend that we adjourn.
Mr. Chair.
Mr. Affley has the floor.
Simply, Mr. Chair, to perhaps suggest or maybe even move. I think the presentation last given was lengthy, but presented some perspectives that I think need to be taken on board, certainly a level of reflection. So I would want to suggest we invite a formal documented presentation if that's possible. And I think I heard in fairly strong terms from the doctor, not Dr. Blendman, I just spoke with reference to the doctor to her right. And I would like to propose similarly with respect to that, if I may.
If they so but we have a Hansard reporter.
Yeah, Hansard report is fine, and we applaud them for the wonderful work that they would do. They didn't present, and if the presenters are minded so to do, I am simply proposing that we invite that. The choice is theirs.
She presented, but Connell didn't present.
The recommendation is for us to consider written proposals if they so desire. Do we have a seconder? So the proposal is for us to receive written proposal if the presenters so desire. Those in favor say aye, those who are not say no. Methinks the ayes have it. So we will receive the written proposals.
Only to say that our presenters must not feel that they're compelled in any way by this committee to submit anything in writing. I'm sure that the invitation would always be either in writing or orally or both.
But no. Dr. Brown spoke earlier of a but. I'm entitled to also make reference to buts. But we're not compelling anybody. But the motion was clearly made that we invite them so to present if they're minded so to do. Then the compulsion in that.
And I just want to make it clear that there is no compulsion in that, and you and I are absolutely in agreement. There is no compulsion in that. The gravity of a select committee of Parliament inviting people to make a written submission would certainly lead them to believe that they were somehow or another obligated to do so. And you and I agree. You and I agree. You and I agree.
We may agree, therefore your remarks were totally unnecessary. These are intelligent people who understand that if they want to do so, they may.
You're an intelligent person who understands that you cannot compel them so to do. Next thing you should do is move the adjournment.
Pardon?
Yes, ma'am.
Okay, we will all agree that we have had a long and productive day. Very informative and thought-provoking discussion. I will now ask for a proposal for us to adjourn. And second, we will adjourn until the 24th. Those in favor say aye, those who are not say no. 24th is what day? Tuesday.